Hello student, here we study the subject which is element of company law. In that, firstly we study the definition of company. In that, according to section 2 under section 20 of the Company Act 2013, company means a company incorporated under this act or any previous company law. In general, a company is an artificial person created by law that has a separate legal entity, perpetual succession and common seal and has limited liability. The Company Act 2013 defines a company as a separate legal entity that is incorporated under the Company Act or any previous company law. These features are explained below. That a company having a separate legal entity, it means a company is distinct from its members and has similar rights and powers as a human being. It can own property, enter into a contract and sue and be sued in its own name. The next point is perpetual succession means continuous life. A company can continue to operate even after its members die or change. Then artificial legal person. It means a company is created by law and is considered a legal person in its own right. It also can act only through human agencies such as its director. The company's word is come from the Latin word means com means together and panis means bread. Here we discuss some characteristics of company under the law. In that, first one is artificial legal person. Artificial legal person means a company once registered become a juristic person. The existence of the company is there by virtue of law. It does not have physical existence like a natural being, but it has certain rights and duties just like a natural person. A company has nationality and domicile, but it is not a citizen and has no fundamental rights under the Constitution of India. Then second characteristic of company under law, which is separate legal entity. It means after incorporation the company acquired a separate legal identity which is separate and distinct from the personality of those who constitute it. Being a separate legal entity, it enjoys some features like it can hold property in its own name, it can open an account in the bank and its own name, it incurs debt, it can file a suit in the court of law, also it can sue and sued by others. Also, the next point is limited perpetual succession. Perpetual succession means continuous life. The one point is limited liability. Limited liability means in case of a company limited by shares, the liability of shareholder in a company is limited up to the value of the shares held by them. In case of companies limited by guarantee, the liability of members is limited up to the amount guaranteed by them. However, in case of companies with unlimited liability of members, limited liability of the members continue till the debt have been paid by the company, but this privilege of limited liability is not absolute. It has been diluted by the section 339 of this act. The next point is perpetual succession. Perpetual succession means a continuous life. A company having continuous life, once a company is registered as per the previous provision of Company Act, it is continue to exist till it's finally wind up as per the provision of the act. The membership of the company may keep changing from time to time, but it does not affect the existence of the company. After the death of the member, the shares are transmitted to their legal representative who will be assumed members of the company. The next point is transferability of share. The capital of the company is divided into parts and each part is called as a share. Share in a company are considered as movable property. Hence, such shares can be easily transferred by one member to another person or another member like any other sellable commodity. In fact, this facility is called as a transferability of share, and the objective behind the emergence of an idea of joint stock company in 19th century in England. Due to this facility, large undertakings could emerge around the world. Share transfer transaction take place in accordance with the article of association of the company in that section 44. But in case of private company, the right to be transferred to the share is restricted as per the section 58, 59 and 60 also. The next characteristic is common seal. Common seal, or we can say that it is a substitute for signature. A company not being a natural person cannot sign document for itself. Therefore, a company would require some other facility to authenticate or approve the document. The common seal with the name of the company engraved on it. So, uh, as an being to make a document and authenticate that time, a company's common seal is required for that, as well as the signature of the director is also required for that. If the common seal is there but the signature of the director is not, that time we can say that this is not an authenticate or valid document, or a signature is only there but not a seal, common seal is there, that one is also not a valid document. And the last point is, last characteristic is voluntary association for profit. Yes, company is created to earn more and more profit, so it is a voluntary association for a profit. Then our next point is types of the company. In that, we can say that some company is having some categorization on the basis of incorporation, on the basis of holding or liability, on the basis of number of members, on the basis of ownership, on the basis of management liability. The company having different types. In that, firstly we study on the basis of incorporation. While we are saying that the company incorporation means a registration, in that, first point is chartered company. Chartered company means those company which are formed by the royal charter and no longer existence in India. Of the example of chartered company is East India Company. Then next one is statutory company. Statutory company means those companies which are created by special legislation of parliament or state legislature may be called statutory companies. For example, LIC, we can say that Life Insurance Corporation, Food Corporation of India, Reserve Bank of India, RBI, the State Bank of India, then Unit Trust of India means UTI. Such corporations would not require any memorandum of association because the act by which it is created would certain all these necessary rules and regulations for the proper functioning of such corporation. And these corporations are mainly concerned with public utilities such as railway, gas, electricity companies having its importance all over the country. Then the next point is registered company. A registered company is established by registering it with the registrar of the company under the Company Act 2013 or under any other previous Companies Act. All existing companies in India except the statutory company have been formed in this manner. In that, then on the basis of liability, we can say that on the basis of liability, there have the company which is uh, company limited by shares, means those company whose capital company having the liability of its members limited by memorandum of association to the amount if any unpaid on the shares respectively held by them. It is termed as the company limited by shares in this act, as per the act. The name of such company end with the word limited, which signifies that the liability of the member is limited to the nominal value of the share, which is how much shares held, the value of the share held by the person. The liability can be enforced while the company is in existence as well as during the winding up of the company. The next type of the company is company limited by guarantee. As per the section 2 under section 21, a company having a liability of its members limited by the memorandum of association to such amount that as the member may respectively undertake by the memorandum to contribute to the asset of the company in the event or of its being wind up is termed as a company is limited by guarantee. In case also the liability of the member is limited, the article of such company should state that the number of members with which the company is to be registered. Generally, such companies are not the profit making companies because they are formed for the purpose of promotion of art, science, culture, charity, sports, commerce, or any other, etc. Such companies may be with the or without share capital. They may be public or private. They are also called as a guarantee company. Such company does not have power to buy its own shares. The next type of the company is unlimited liability company. Means a company not having any limit on the liability of its member is termed as an unlimited liability company. The unlimited company can be either a private or a public company or a one person private company. However, such companies are very rarely formed. In the memorandum of such a company, there is no declaration about the limit on members' liability. Then the next type of the company is on the basis of number of members. In that, private company is there as well as public company is there. Private company means those company which has a minimum paid up capital of 1 lakh rupees or such higher paid up capital, or you can say that restrict the right to transfer its shares, as well as some points are there. Expect in case of one person company, limit the number of its members to 200, as well as the private company is control managed by some, or the control and management of these companies is concentrated between very few hands. Then the next type is public company. Public company means a company which is not private company, which has a minimum paid up capital is of rupees 5 lakh or such higher paid up capital as may be prescribed. Then the next point is, next type of company is on the basis of control. In that there have two types, which is holding company and subsidiary company. Holding company means a company is considered to be holding company when that other the which hold the other company. The second company to whom that holding company hold is called as subsidiary company. The second point is subsidiary company. Second type is subsidiary company under section 2 subsection 87. A company is known as a subsidiary of holding company in the following three circumstances. There have some circumstances, on the basis of that we can say that that company is subsidiary company. In the first one is where a holding company control the composition of board of director of such a company. It means, for example, holding company can hire and fire director of a subsidiary company. The second point is where holding company exercise more than one half of the total share capital, either at its own or together with one or more of its subsidiary company. And third one is where one company is a subsidiary of another, which is itself the subsidiary of some other companies. The first mentioned company becomes a subsidiary and the last mentioned subsidiary of the last mentioned company. Then the next point is on the basis of ownership. In that, first type is government company. Government company means any company in which not less than 51% of the paid up share capital is held by the central government or the state government, or partly by the central and partly by the state government. These are called as a government companies. Then second is non-government company. Means it is like a private company, and you can say that the less than 51 shares is held by the government. Then next point is foreign company. Foreign company means those company who registered out of the India or other in other country and doing their business in India. These companies are called foreign company. And the next point is, next type of the company is one person company, or we can say that one man company. This is a company in which majority of the shares are owned by one person only. This one person virtually hold entire share capital of the company with a few extra members holding just one or two shares each for the purpose of completing legal requirement of minimum number of members. These extra members are generally his relative, friends or nominees, but ultimately he is the dominant shareholder and hence he enjoy complete control over the company. It also therefore he can enjoy the maximum profit of the company's business with limited liability. In the eye of the law, such companies are perfectly valid and legal. The next type of the company is here. The next point is why form a company, means benefit of incorporation. There have some benefit enjoyed by the company when the company is registered, or we can say that incorporated. Which benefits are there in that? First one is limited liability protection. Yes, the protect the personal asset and shareholder. Then second is separate legal identity. It also allow companies to operate independently from their owners. Then next is perpetual succession. This benefit is also enjoyed by the registered company, which is ensure continuity even if ownership change. Then ease of raising capital. Yes, a company which is registered can easily raise their capital. And also tax benefit is there. The company which is registered getting the tax benefit with some lower tax rate and other incentives is also there. Then next point is there have some stages of in the formation of the company. In that the main four stages are there. First one is promotion stage, second one is incorporation stage, third one is subscription of capital stage, or you can say that capital subscription stage, and last one is business commencement certificate stage or commencement of business stage. After completing all these stage, company is registered and as per the company act, then they can start their business. Only public company can start their business after getting the certificate of commencement of business, but a private company can start their business only after completing the second stage, which is incorporation stage. After completing incorporation stage, company get a certificate of registration and a private company can start their business.